Today, Kenyans can enjoy state-of-the-art services at the judiciary, right from the infrastructure to the service provision. With a solid transformation strategy geared towards a more people-centered service delivery, the judiciary has been undergoing dynamic fundamental transformation from the old order to a more effective, independent and accountable system. Sensitive to the new constitutional order that stipulates that the judiciary must deliver justice to all speedily, while also providing alternative forms of dispute resolution to promote, protect, and advance the constitutional principles. For most of its history, the Kenyan judiciary has been perceived as far from a faultless handmaiden of justice and guardian of human rights. From the inception of the colonial Kenyan state in 1895 to date, the public has had its fair share of issues with justice delivery. The near-total collapse of justice and public accountability in the years before the 2010 Constitution seriously undermined public confidence in the judiciary, so dear and important as one of the three core equal arms of government. Through a four-pillar transformation framework launched in May 2012, the judiciary is implementing a transformative leadership that is fast bearing fruit. The four pillars are people-focused delivery of justice, transformative leadership and organizational culture, adequate financial resources and physical infrastructure, and harnessing technology as an enabler for justice. This four-pillar framework is equally cognizant of a management policy that mainstreams issues of gender, disability, and diversity in the judiciary. A fully fledged Judiciary Transformation Secretariat operating under the Office of the Chief Justice is the captain of the transformation strategy.
We are transforming. The judiciary is transforming. And today, we have new impetus to do more.
The vetting of judges and magistrates is one of the key contributing factors towards building of public confidence on the judiciary. A rigorous judges recruitment exercise was done before the media, showcasing a clear break from the past appointments. Under Pillar 3, on adequate financial resources and physical infrastructure, the judiciary is implementing a 10.2 billion shillings infrastructure project supported by the World Bank to build more courts and rehabilitate existing ones.
In the future, however, the judiciary envisages a situation where funding comes entirely from the national budget. Not only would this secure the independence of the institution, but also promotes accountability.
Among the many notable milestones as regards the expeditious delivery of justice is the establishment of legal and administrative systems and mechanisms in the management of disputes related to the March 4, 2013 general elections. The introduction of mobile courts is also a refreshing addition, bridging the gap between justice and the people. With over 45 harsh-terrain vehicles and the investment in motorboats, indeed justice is being served. With a realignment of ICT policy and strategy to the ongoing transformation, the creation of an e-framework will enable the expansion of the Ombudsman to receive and deal with public complaints.
The service desk of the Judiciary Ombudsperson helps you navigate by giving you an overview of all new tickets created via email or SMS.
A fundamental constitutional mandate of the judiciary is to promote and protect the purpose and principles of the Constitution. And this is where defending and promoting democracy through free and fair election, the judiciary has risen to the occasion quite ably. Regarding the March 4, 2013 general election, the following measures were put in place. The establishment of a Judiciary Working Committee on election preparations. Judges and magistrates were trained on election dispute resolution. Magistrates were set aside to hear petitions at the county level. The public was sensitized on our election preparedness. The annual leave for judicial officers was postponed. Advanced case management systems were installed. Presidential, parliamentary and county petition rules were put in place. Transparent recruitment of judges and magistrates. Appeal court was decentralized to Nyeri, Kisumu and Mombasa. And 47 judges and 47 magistrates were appointed to swear in county leaders. These are just among the many steps taken to give you, the Kenyan, the service you deserve as the one who has delegated to us the judicial authority we exercise. At a glance, this is a state of play in the judiciary so far. You, the ordinary Kenyan, is why the judiciary exists. That's why every year we give you a full week through the now customary judicial matches to interact with judges and magistrates so that we can hear from each other. This is your judiciary, a judiciary in motion.
I, Uhuru Kenyatta.
I, William Samoei Ruto.
Viapo ambavyo ameapa.
Date 9th April 2013. Venue Kasarani International Sports Center. Kenyan history gets a fresh new chapter as the first Chief Justice under the new constitutional dispensation presides over the swearing into office of Kenya's fourth president and his deputy. Presidential inauguration ceremony was the pinnacle of an intense electoral process for the country in general and the judiciary in particular, whose role here was to preside over the transfer of power from Kenya's third president of 10 years, Mwai Kibaki, to a new leader.
Haya, tumshangilie.
As if to echo the national anthem spirit that justice be our shield and defender, the judiciary had cleared the decks in line with the law for the constitutional transfer of power. We rewind to August 2010, when the people of Kenya adopted a new constitution that, among its many provisions, outlined the mandate and the role of the judiciary in the electoral process. The new constitution also triggered radical changes in the judiciary, among them the establishment of the Supreme Court and the vetting of serving judges and magistrates. Under the Judiciary Transformation Framework that was launched in May 2012 to improve service delivery, a lot has been achieved.
The judiciary's role is basically dispute settlement, and this goes throughout the whole election cycle. Actually, from the date of the election is announced and registration of voters. So at each stage, whenever there's a dispute, the judiciary has to come in and resolve that dispute. One of the biggest challenges, you remember, was the debate about the election date. Another very big, very contentious issues. We had 136 cases. We settled all of them within the time limited by the Constitution. Along the election cycle, there have been cases even about procurement, for example, of election materials. We've been able to deal with the cases effectively and efficiently.
Other landmark pre-election court rulings made by the judiciary included cases on ethics and integrity on some of the presidential candidates, and another on the exclusion of Kenyans living in the diaspora from the 2013 voting exercise. Recognizing the special role assigned by the Constitution in the electoral process, Chief Justice Willie Mutunga established the Judiciary Working Committee on Election Preparations, JWCEP, to prepare the institution, one of the three core equal arms of government, to prepare the judiciary for this critical task as the clock ticked towards March 4th, 2013, the date for Kenya's first general election under the 2010 Constitution. In the ongoing judicial reforms, the country has seen the improvement of access to justice and overall service delivery, significantly boosting public confidence in the transformed and independent judiciary. After the 2013 elections, the Supreme Court was called in after a dispute hit the outcome of the presidential election. The Supreme Court, in its exclusive jurisdiction, was charged with the responsibility of hearing and determining the presidential election petitions. To ensure transparency, the Supreme Court conducted the presidential petition proceedings in full glare of live TV cameras that beamed the sessions to a national and international audience.
There is always an assumption, my lords, that the Attorney General is a man or a woman of some reasonable experience. By his experience, by his writing, by his research, by the endeavors to understand the legal questions, only the legal questions, the court would like to hear, to that limited extent only, the reflections, the thinking, and the research that the Attorney General may avail to the court as its friend.
How can the result of the presidential election from that constituency meet the standards of the Constitution?
Where were these special registers used? Nobody knows. Where were they used?
Let them operate by the rules of the same game. The rule is there will be winners and losers. And winners and losers are in the political arena.
It was our response that we used the Green Book for purposes of allowing a person to vote. That particular Green Book was exhibited in an affidavit of the returning officer.
As you interrogate what is the real true meaning of these provisions of the Constitution, you must necessarily fall back on the statutes, the regulations that are used to implement the electoral processes in this regard.
But my lord, my learned friends have told you to keep many things at the back of your mind if there is space, which I am sure there is.
Due to the renewed public confidence in the judiciary system, over 180 election petitions were filed in various courts across the country by the close of 28-day period set by the Constitution. The Chief Justice named 98 judges and magistrates to deal with the petitions and also appointed Justice David Majanja to head an ad hoc division of the High Court, the Election Disputes Resolution Division, to coordinate the entire election dispute resolution process.
Key mandate was to train judicial officers, and because training is very, very important, particularly at this time where we had a new constitution, we had new laws, we had judges and magistrates who had never dealt with election cases and election-related disputes. We had the mandate to engage other stakeholders because we thought in the past the judiciary has been accused of inward looking. Now we had to engage with other stakeholders because an election is not carried out by one institution, it's carried out in cooperation with other institutions.
The Supreme Court judges worked tirelessly, conferencing in their private lounge at odd hours, and had even harder task writing the judgment, as these exclusive pictures obtained by the Judiciary Media Service show. Yes, the Supreme Court bench at work, writing their judgment in an undisclosed location, a judgment that was to be delivered in a matter of hours to an anxious nation. During the presidential petitions pre-trial conference in Nairobi, the Supreme Court narrowed the issues raised by the parties to 4 broad questions. First, whether the president-elect and deputy president-elect were validly elected. Secondly, whether the presidential election was conducted in a free, fair, transparent and constitutional manner. Thirdly, whether the rejected votes ought to have been included in determining the final tally of votes. And fourth, being on consequential declaration orders and reliefs. After 5 days of court proceedings, the judges were ready to give a ruling on the presidential election petition.
It is the decision of the court that the said elections were indeed conducted in compliance with the Constitution and the law. It is the decision of the court that the third and fourth respondents were validly elected.
In summary, the evidence in the opinion of the court did not disclose any profound irregularity in the management of the electoral process, nor did it gravely impeach the mode of participation in the electoral process by any of the candidates who offered himself or herself before the voting public. It was not evident on the facts of the case that the candidate declared as the president-elect had not obtained the basic vote threshold justifying his being declared as such.
God bless Kenya.
Having delivered the ruling, the judiciary assumed its next responsibility, that of preparing the inauguration of the duly elected president and his deputy. Unlike in the past, where the president was sworn in soon after being declared winner by the Electoral Commission, this time the procedure and steps for presidential inauguration were spelled out in law, and the judiciary was at hand again to do the honors at Kasarani International Sports Center in broadcast daylight.
I, Uhuru Kenyatta, in full realization of the high calling I assume as President of the Republic of Kenya, so help me God.
I, William Samoei Ruto, in full realization of the high calling I assume as Deputy President of the Republic of Kenya.
The decision to turn to the courts and the judiciary's handling of the presidential petition demonstrates the increasing faith in the judiciary and the institution's role in entrenching and promoting a credible democratic culture, the rule of law, and constitutionalism. The judiciary is one of the 3 state organs to which the sovereign power of the people of Kenya has been delegated. The objectives of the judicial transformation are to reset the relationship between the judiciary and other arms of government,